Okay, I'm going to talk to you about the 5 pitfalls of making redundancies. First of all, I want to consider the selection pool. It's common for people to make a pool which is too narrow. So for instance, you might identify a position for redundancy and it might be the head of the particular department, but you forget to include also the assistant because the head has got interchangeable skills with the assistant, could easily slip into that role. And you might find that you then get a claim for unfair dismissal because the pool was restricted to 1. An example is a case that was heard in the courts about a farm fishery business where they had different fisheries around the region and they only restricted the site to one of those fisheries. The court said that was unfair. Second pitfall is suitable alternative employment. It's important to make all potentially redundant employees aware of alternative vacancies within the company and within the group. There's a special rule that applies to employees who are on maternity leave. If they are provisionally redundant and a vacancy arises, they have to be offered that vacancy. Not just invited to apply for it, they have to be offered. This is one of the rare cases where we see a sort of reverse discrimination in employment laws, positive discrimination. Thirdly is the method of selection from that pool. It's important that employers draw up objective criteria against which they'll score each individual employee. Importantly, describe each score. So you might score from 0 to 5. Describe what each number means so that the manager who's applying the scoring matrix knows exactly what they're doing and can explain how they've arrived at those scores. If you're going to make 20 or more employees redundant within a 90-day period or less, there has to be a minimum 30-day consultation period, a collective consultation with employee representatives or unions. If there is no recognised trade union, then the employees need to be invited to elect representatives and you will have meetings with those representatives. Now, in a 30-day consultation period situation, you don't have to carry out the consultation throughout the entire 30 days. What it means is, from the start of the consultation, it has to be at least 30 days before the first dismissal takes effect. What I advise employers to do is have a series of frequently asked questions that we can present at the first collective consultation meeting and add to them as the meetings progress, as other issues crop up and as answers are given. And finally, it's important always, whether or not you've got collective consultation, to have individual consultation one-on-one with those employees who are provisionally redundant. And it must be meaningful consultation. This gives them an opportunity to explore and suggest to you as an employer any alternative that they may come up with. You don't know, for example, whether an employee might suggest a job share with another employee, and that's something that you need to show you've considered. If you want to be seen by an employment tribunal to have acted fairly, and that's where these cases can sometimes end up. So there we have it, the 5 pitfalls of making redundancies.